Hi, everybody. I can continue eating. I know many of you, and it's nice to see some old faces from last year. Welcome. My name is Omri Ben-Shahar. I am a contracts law professor here. And I'm going to lead a discussion, first speak for about 15, 20 minutes, but want to solicit reactions, discussions, views on an issue that is kind of on a borderline between a serious scholarly exploration and just a provocative idea for a discussion for a roundtable discussion. I'm totally serious about it, although in a way that I'll have to explain what it is. The idea is called one-way contracts, and let me just preface it by explaining what am I trying to accomplish by this particular study, what part of what project it is. So I'm interested in consumer protection and in ways in which we can, the government can help consumers survive in the marketplace in which they deal with sophisticated businesses and reach better outcomes. I think that the recent mortgage crisis, for one, and financial products crisis more generally illustrates that we are at a loss. We don't really know how to prevent these things. Regulations of old don't seem to have worked, and there is kind of puzzlement what to do. Been participating in the meetings with the Fed and with some other regulators, FTC, so they're all kind of trying to figure out what to do, how to protect consumers better. And my project, in a sense, started before the recent meltdowns. I don't want to say predicted that, because that would be presumptive, but the project developed several ideas that suggested that what we've been doing for the last generation or two in terms of consumer protection is not working, cannot work, and needs to be revisited. And specifically, I talk about three pillars in consumer protection law that don't make sense. One of them was the subject of my COES lecture last year. Those of you who attended it might remember the whole idea of disclosure, mandated disclosure, giving consumers information. So protect consumers by giving them information that doesn't work. I discussed then a study in which I read several hundred statutes of disclosure, basically all of the disclosure statutes in Illinois, Michigan, and California. And I made the very ambitious claim that not a single one helps consumers. So information doesn't work, and it's obvious why, and I explained then why. Try to read these disclosures, what it is that consumers are being informed about. It's completely unhelpful. Another element that I'm not going to talk about today has to do with equal access. Consumers have to be secured some kind of access to primary fora and platforms in our society. Not that I'm against access. I think access is a very important democratic notion and that reaches far beyond consumer law. So access to health is something that is now being debated, but we generally think that wealthy people should, in some sense, subsidize the access of less wealthy people to platforms and institutions that are democratically necessary. Education, public beaches, health. We can debate what are the things that include in this mandated access. But the idea of mandated access has been stretched to protect consumers' rights, for example, to go to courts, versus being compelled to go to arbitration. I argue in that element that equal access doesn't help consumers. It helps consumer elites. It doesn't help the true sectors and consumers that need more help. But that, again, is not exactly the topic of today. Today, I'm going to talk about another element of the consumer protection law. It's not information, it's not access, it's remedies. The idea that to help consumers, they have to be granted more substantial remedies when the business breaches the deal, the contract with them. And I think that that's a misguided priority. It could be potentially helpful here and there, but to consumers as a whole, it's not only not going to help, it's not helpful, I think it backfires. Overall, focusing on that will make consumer worse off, not better off. And so to deliver this idea, I developed the following thought experiment. Imagine a consumer to business contract with your cell phone provider. Say, we all have those. What if, there are a lot of elements there. What if, the business can enforce the deal on you? You have to make the monthly payments. You have to pay the termination fee if you prematurely terminate the contract. The things that are pro-business there. But what if you can't enforce the contract against the business? So, the service breaks down and you complain. You cannot, you have no recourse against the business on anything. The warranty on the phone, return policies, you name it. Or, more generally, every consumer contract gives some rights to the business and some rights to the consumer. The business can enforce its rights for timely delivery and timely payment and all that. But imagine that the consumer cannot go to court to enforce his or her contractual right, or whatever they are. Many of these contracts are not very pro-consumer, so there are not many rights to enforce. But there is, at the very least, the right to get the goods or the services. Suppose they are not delivered. You want to sue. Well, you can't sue. In a one-way contract template or regime that I offer you to think about, the consumer cannot sue. And so this is the idea. And the argument is that this is pretty good, for consumers, or pretty good. That this could make consumers as a class better off. How could that be? Well, first of all, let me just suggest that we already have one-way contracts. This is not a kind of a fantasy and a crazy, impossible regime. In many ways, once you study contract law, you realize you cannot have a contract that is only one way. Contracts have to be two-way or else they're not contracts. My students here, that's a topic for tomorrow, the doctrine of mutuality. So you're getting a head start. But set that aside. Practically speaking, think of contracts you have at a supermarket. When you go to the grocery store, the supermarket. What's the contract? Unlike many other transactions that you enter with businesses, even retailers, there is no pre-printed form that you agree. There's no click I agree to anything. There are no terms of use that are part of some link, like when you shop in e-commerce. There is no, is there a warranty? Does the store give you any warranty? Is there a return policy? Some department stores have big signs with return policies. Did you ever see one at the local Treasure Island? Do you know what it is? Is there one? What's the contract? What happens if if they, after they rang the cashier, they forgot to pack something? Can you sue? What if they charge you the wrong price, or the goods were not as described? There are all sorts, of course there are obligations. And as many of you that have taken contracts might recall that some of the issues in contract law are explored through these pedagogical example of supermarket contract. What is the offer? When is the acceptance? Things like that. So there is, we can construct a contract and say there is a contract and here's what it is. But most consumers don't go through the ritual of finding a contract the same way that in many other contracts they exist. I argue the same thing with restaurants. What is the contract? What if there is, piece of wire in the pasta? They might give you, but can you sue if they are insisting, no, we're not going to remedy the situation? What about taxi cabs, taxi rides? Are these contracts? Or what are the contracts there? Do you sign any agreement? What if the taxi driver makes a mistake and takes you to the wrong airport? You miss a flight. Consequential damages, do you get them? In all of these situations, I made a search, did some last year. There's not a single case in the US in which parties sued the businesses that manage the grocery store, supermarkets, taxi cab companies, or restaurants in a contract suit. There are other suits for tort, if there's a great harm that you suffer. There could be suits for violation of regulations like misleading advertising, but not a contract suit for contract damages. There is no contract. I mean, you can back out. Again, a pedagogical contract exists. Practically speaking, there is no contract. So there are these. Now I'm suggesting let's have that everywhere. Mortgage contracts, buying cars, cell phones, telecommunications. Everything should be like that. No contract. Why? You know, what? But here's the big question: is why is that better for consumers? Why is it that you know, other areas where they do have printed forms, they are part of that ritual that they get a deal and they get some rights? Shouldn't they at least be able to enforce it? It's not easy for consumers to enforce, to find a lawyer, the resources, the time, the stakes to do that. But suppose they want to do it, shouldn't they be able to? Well, and wouldn't they be worse off without that? Well, I argue, no, they're not going to be worse off, because we have to recognize that contract enforcement is only one of several potential protections that consumers can have, and there are other ones that are quite potent and that could become even more potent if the contract enforcement protection doesn't exist. What are the alternative protections that I'm going to talk about? I'm going to talk about 4 different areas, types of protections that consumers have that are non-legal. One has to do with just redesigned transactions. If you know that you're not going to be safe and secure, and once you pay, the business can screw you, you're going to be much more careful, and you will enter, you know, the same way that cats take steps when they go outside the window. They just take one little step and make sure that there is solid ground, and then another one. You'll take these small cat steps, and I call this redesigned transactions. First of all, consumers will insist on right to inspect, and inspection will become much more important before the contract. Second of all, they will not make long-term commitments, because again, they don't want to rely on the promise. They will break down the commitment into many short-term commitments. Instead of buying a car, you will rent a car. Instead of renting a car, that's also a commitment, you'll use zip cars. So breaking it down, chopping down the transaction into smaller and smaller segments, such that if you feel that what the value that you're getting is not good, you can't do anything about it, but you will lose very little. The 1 hour, the $8 you paid zip cars for an hour, that's what you lose if you're not happy. Where instead of the $20,000 that you would lose if you bought a car and you're unhappy, you didn't get it. The car wasn't there. You lost $20,000, nobody to sue. $8 with zip cars is not as bad. Instead of buying a computer, you will lease a computer. Instead of cell phones, you'll have prepaid phones. Can imagine how technology can help us chop down the transaction so that we put less at stake and we will be less at risk, and can do these many. Now, there is a loss of value from having to do many small one-shot deals instead of one continuous deal that we can rely on and develop expertise in using. But we can think of technology developing all sorts of clever ways to have these less, the breakdown of the transaction less costly with less deadweight loss. I mean, I think zip cars is a great metaphor for how to do that in a way that's not too necessarily costly. So that's one protection, redesigned transaction. Another one has to do with bonds and assurances. If you can't get a promise that is enforceable from your retailer or seller or business, maybe someone else can assure that. You know, when you use your Visa or American Express, and you're not happy, you got, the merchant did not deliver, they didn't make good of the promise, you can call the credit card and they will, in many circumstances, give you your money back. And then they will blacklist the retailer or do something, but they will help you with that. Or you can purchase assurance from squaretrade.com every time you buy something. Or you could think about eBay Motors. People buy cars for tens of thousands of dollars from potentially fly-by-night sellers who have no shop, you've never met, across a state, give their money up front, used cars, sports cars. You never know what you can get. A colleague of mine once bought $28,000 sports BMW from someone in California, never saw the car, just pictures, never met the seller, gave the money up front. Why? Because eBay guarantees it. They are the market maker. They've set up a market. They want buyers and sellers to come there. Buyers and sellers would be reluctant, so they assure the transaction. The same way that the credit card or the payment system or PayPal would want you to use their currency. They tell you, if you use our currency, you are safer than using cash. So these intermediaries provide bonds and assurances. Now, you're probably clever enough to recognize, but wait, like, intermediaries are already also businesses. Why your contract with SquareTrade.com, is that a binding contract? I say no. These have to be enforceable, either because we say, no, assurance contracts are enforceable if we think that they should be. I don't think they should have any special exemption. Or because we say they will be self-enforcing due to other sources that we will continue to mention. So we have these kind of examples, or seals and trademarks could be another source of protection, assurance protection. If a particular company puts its seal and says safe trade, without making any assurance, it just said, look, we have examined people's experiences, whatever, and we are giving it the ultra seal. Then you can rely on that. You don't have any contract with them. They're just providing this kind of information. So that's another source. So bonds and assurances are type of a consumer segment. Another one that I developed in this study is the idea of an insurance product. You buy insurance not for fire, not for health, not for liability, but for your own losses as a result of contract breach by businesses. The contract breach peril, call it in insurance terms. I think that could be an interesting thing. It doesn't exist. But instead of being protected on the basis of buying some kind of safety from SquareTrade per transaction, you buy it per consumer. I buy it now for a year for all my contracts. If I ever have lost a breach of contract against me, I'm covered up to my consequential loss. So if I buy a pen and the pen spills its ink on my expensive Armani suit, I get an Armani suit. That's breach of contract. That's more than what you would get usually, a new pen. I don't want a new pen. I want a new suit. That insurance can give you that. Contract breach, rarely would, never would. So, and think about it. Insurance contracts, what do insurance contracts do? Everybody always says, oh, they spread the risk. That's a very small part of their social value. What insurance contracts are good at is verifying that claims, they have the expertise to verify that claims are valid, meritorious, much better than courts. They can make sure that you don't have a track record, you're not a complainer, they know your history, and they can charge you according to it. They can aggregate information and figure out that there's a particular maker of particular product that everybody keeps complaining about the product. So they can blacklist that maker and say, if you want to buy insurance with us, no, and we're not going to cover any product from this particular maker. There's no better deterrence against business misbehavior than being blacklisted by an insurer. Or they don't have to blacklist. They can just price. If you want to buy a gateway computer, fine. But our records show actuarial data, nothing ideological, that gateway is subject to 3 times as many claims as Compaq. So they will increase your premium. And now decide which premium, with or without gateway. Things like this create both deterrence and compensation without creating any rights to sue the business. Even the insurance company cannot turn around and sue Gateway because they have no insurance term jargon. They're not subrogated. When you are hurt by a tortfeasor and your insurer pays you, they can turn around and sue the tortfeasor. That's called subrogation. They won't exist here because I don't have any claim to give the insurance company to sue on breach of contract. But they nevertheless create deterrence against breaching parties by pricing the insurance against the insurance accordingly. The one thing that needs to occur in this regime is that insurance contracts, unlike any other business-to-consumer contract, have to be enforceable, and that is an exception I have to live with. By the way, insurance contracts are not considered consumer contracts. For one, because insurers are not consumers. Every insurance contract is different. They are not the same, even though the forms are the same. People have different deductibles, different terms, different prices. They are priced differently according to age, gender, record, and so on. So there's not this uniformity that we see in consumer. And it also lacks another element of consumer transaction, namely the incentive to sue. Insured who thinks that the insurance company is denying coverage in bad faith or in breach of the policy can sue. Because usually the loss is large, the coverage. It's unlike, the loss from cell phone that doesn't function. The insurance deal gives the insured a right that is very valuable. In any event, insurance is another way to safeguard consumers in the event that they have, if these insurance contracts can be enforceable in a one-way contract regime. Finally, there is what I think is the most promising safety or protection measure. It rests solely on markets, has to do with reputation and ratings. When you go to, if you want to go to, I don't know, Cairo and check into a hotel. You've never been to Cairo and you heard terrible things. There are hotels that are maybe good, some bad. You've got to watch out. How do you know? Well, you might ask someone that went to Cairo to recommend to you, but that's a very limited set of information to rely on. Maybe you're missing out on some good. Luckily, today, you just log in to Expedia.com or to hotels.com, click Cairo, and you get 100 hotels rated on a 1 to 5 star measure with respect to 3 or 4 different things that matter to you: service, cleanliness, price, and things like that. And you rated by people that lived there before, that stayed there, sometimes hundreds of people, aggregating this amount of information, and you can make a fairly safe choice. You're not likely to have a much different experience than what these people had. So it's taking the word of mouth kind of idea, that asking a friend to recommend to you, and multiplying it by hundreds and more experiences. That's the same thing that we see all over the place. Now, eBay exists solely because there is a valuable rating scheme. Most of the sellers on eBay don't have shops, don't have reputations. They could be fly-by-night, as we mentioned before. I'm not talking about cars, about small things like, USB adapters. Why do you buy from them? Why do you send them money up front? Partly because PayPal secures it, but not always. Sometimes people pay by checks. Why do they do it? Because the seller has a 99% rating. And if it's lower, if it's just, God forbid, 97%, you will not go to that seller. The standards are very high. Ratings create markets, create safety for consumers, and the challenge is to take it from things that are trivial, like USB adapters or even hotels, and develop it for big things, like mortgage products, insurance products, doctor visits. Angie's List does a great job expanding it for things that beforehand were difficult to compare, but it's not clear how well it does it for doctors and dentists. But there are emerging, in the internet, there are emerging services that rate your ratemd.com and rate dentists and things like this. And 5 or 10 years from now, these will provide information that is sufficiently rich for people to make good decisions on the basis. So I think that this is a very good way to protect consumers. This is the new workhorse of consumer protection, ratings. And that should be developed, and if anything, if government has the role, it's creating some standards so that you can be able to know what these ratings measure, and that these are, you can trust some ratings because they proliferate and there are many of them. But other than creating basic standards, they should not do, which is a coordinating role rather than mandating role. They shouldn't, the same way that the government regulates adapters and switches and all sorts of hardware and software compatibility, just so that everything will be compatible and coordinated well. We don't have to have wasteful investments. They could regulate that, but not more. We don't need the government to actually get into the enforcement of the deals. The deals will be self-enforcing with these things in existence. I'm already going beyond the time I was hoping to speak. I can continue, as you see, and talk about this forever, tons of examples. I will stop here because I want to solicit your views, objections, and open it for discussion, please. Yeah.
So, first of all, that was fascinating. And I really like your idea of that insurance. But one problem I see with that is that it would hinder new entry into market. So let's talk about the computer example. There's differential insurance prices for different computers, and with a new company, there's more uncertainty, so there's likely to be a higher insurance charge. Under a two-way contract, they could just ensure that the price can be low too.
That's a good point. I, haven't just writing for myself to think about it more. So the argument is, if we have an insurance product and it's priced according to the information that it has, if insurance company doesn't have actuarial data about this particular merchant who wants to enter and offer contracts or offer deals, how would that be priced? And if it could be priced on the basis of some rough averages, but the insurance company will probably have to make all sorts of assumptions to protect itself, and that would make it costlier for people to buy. And you could imagine that, as I said, insurance companies can blacklist merchants. Well, they don't need to blacklist, they just don't include new merchants. You can only buy from Walmart. You cannot buy from a new grocery store, and that's not good. And I think that there are ways around it for entrants. Entrants usually face barriers because people don't know about them. They are reluctant. They sometimes assume the worst about the entrants. Maybe there's somebody new. Who are they? How come I don't know them? There must be a trick. I'm not going to get close to these new places. I want to get the same good old place, always McDonald's. But you can break in to a market by offering better prices, other assurances, bundle it with things that, but it's a challenge, and thank you for pointing that out. Yes?
As far as the ratings system goes, have you thought about how you would regulate who and how gets to participate in the ratings? The issue that I'm thinking of is competitors launching kind of a ratings attack against someone, another one of their competitors in the market. How do we make sure that that kind of thing that's not purely based on consumer opinion or consumer rating agencies' opinions gets regulated or tossed out?
These are a great set of problems, and it's being explored more and more scientifically by people, about, how much can you trust a crowd's wisdom or, mass wisdom. And I think that there are significant problems here. If we hope that the measure would give us some absolute reflection of the quality that's unknown to us, of the merchant, of the product, there's a problem, because who are the raters? They are, most people don't want to bother. Normal people don't rate. Normal people are consumers of raters and rating. So it is people at the extreme, the very happy, enthusiasts, or the very angry, frustrated types. These are not representative people. And then there is the problem of interested parties, competitors, or me rating myself, asking my cousin to put a rating for, ratemyprofessor.com or something like this. Don't trust that, all my enemies. All of that, so the first cut of an answer is, we don't care about absolute ratings. We care about relative ratings. To the extent that all rated parties are subject to these distortions, all we want to see is how they fare against each other. I don't think that, the star system on Expedia give me some accurate, can predict how much utiles I'm going to get, but it can, from staying there. But if I see a place that got 3 stars and a place that got 4.5 stars, it gives me valuable information, notwithstanding these biases. You're also right that sometimes things can be heavily manipulated. And there are great examples, if you look at the web, for people rating themselves and getting caught. There's nothing more devastating to a business than doing that. It proliferates quickly, and the information that you got caught for rating yourself, it's also very easy to see. They're not very subtle. They rate some merchants rate themselves in a way that is just transparent. But good rating services are aware of that. I don't know how to solve it, but I trust Angie's list. I trust Angie to know how to do it, right? The credibility of her product depend on that. And so I'm copping out a little bit, but as a consumer of this information on the web, not just when you buy on the web, but when you buy elsewhere, you go to the web and find information about a restaurant. You're not going to eat online. You're going to go to, but you can find the aggregate information that you find online and elsewhere, in Zagat or some places like that, is very useful. It helps you refine your decision and your choice better than, I think for me, than the hope that, oh, if I'll be frustrated, I'll sue for breach of warranty. Yes?
How much is this proposal based on a competitive market? Can it work in a non-competitive market or in a semi-competitive market?
Well, it's true that a lot of it relies on markets to develop products, and for that to happen, you need many participants to offer you more and more refined products. Angie's List wants to be better, because if not, someone else will do this. But I think that you don't need a competitive market for the insurance protection. You don't need it for, American Express will give you an assurance even if you buy something that is from a monopolized body.
I'm referring to the underlying market for the producer of consumer goods.
Mm-hmm.
Do you require, for example, if there's only one treasure island within 20 miles of Hyde Park?
Yes.
Will your proposal help to solve the problem of treasure island within ourselves?
The proposal doesn't create more competition, and part of what I always try to emphasize to students and colleagues that study contract law is that contract law can do only so much to help create competition. It actually can do very little, almost nothing. If you want to help consumers, the best way to help consumers is to create more competition. If there was, next to Treasure Island, there was another supermarket, then the prices, which are surprisingly high for some products at Treasure Island, would go down to the level that they are where Treasure Island competes. If you go into an amusement park and there's only one burger seller, the price of burger and fries will be $10. But if you go to Main Street and there's McDonald's and Burger King right next to each other, the price drops to $4. So yes, competition is the key to get a better price quality bundles. But I don't think that it is the key for the concerns that we are talking about here, whether the party breaches the promise. What do you do about that? How do you protect yourself against that? Monopoly, competition alike. Yeah.
I feel like what you're saying about splitting up things into smaller, less important contracts, like they really, like leasing a car or just like leasing a computer or something. They're really like, maybe that's really good for consumers, but it's probably not very good for the culture of the country that's using that system. I mean, like, can you just like get married and then be like, well, it didn't really work out. It's just like, I just wanted to try that out for a few weeks. I feel like it's gonna seep into other areas of people's lives that you don't really want it to go to.
Yeah. But let's be serious and think about other examples. I can say a lot about this example of a relationship. The value comes from it being long-term rather than short-term. We think that the short-term relationship, the understanding that it's day-to-day, it takes away something valuable from what it is that we're seeking there. Maybe that's why before people make the long-term commitment, they make a gradual kind of, testing each other out. They first, live together a little bit, then kind of move in, and then maybe buy something together, maybe first get a dog, and then buy a car, then go on a long vacation together, then open a bank account, and then when all these things went fine, these smaller but incrementally larger commitments go fine, they go for the whole long-term commitment. Isn't that a fair way of describing the process? So we see people knowing that there is no contract here. There's no enforcer. You can't go to court and say, they disappointed me. They broke my heart. I want damages. That is no longer part of the law. It used to be, but it's no longer part of the law. You say to yourself, I need to take care of myself. And how do you do it? you chop it down to small commitments, incrementally growing. So in a sense, it is consistent with the spirit of what I'm talking about. And I think the same about cars. You know, you don't know if you like the new Chevy something, the promises are made, so you zip car it, right? Then you like it, it's good enough. Maybe you lease it for a while, and then if you really like it, you'll buy it. So, but you're protected. You're not going to be disappointed. Oh, the promises, the advertisements misled me, and I can't sue on the breach of warranty. Yeah.
Is that efficient? Wouldn't it be better to have the possibility or to have the reasonable expectation if I buy the car, it will fulfill my expectations and I can buy it now instead of waiting a year until I tried it sufficiently out?
Ideally, yes. Ideally, is you would get, you know, I would think that if you could get the promise enforced at no cost, in some kind of, you know, just put in a token and you get your money back or the expectation damages, fine. But I don't think that that's available. And it's either going through an imperfect system of contract enforcement or going through an imperfect system of the other things that I'm talking about, but I want to think of them as substitutes.
Is there a certain amount which has to be at stake, where one system is more appropriate than the other, and is there a point where one can say there is so much money at stake that it is worth trying to enforce?
Yes. So you're right, and I dodged this issue at the outset. What are business-to-consumer contracts? What about these consumer contracts, like mortgage contracts, or purchasing a new, you know, a Rolls-Royce? It's a lot of money, and if you're frustrated, disappointed, and the contract is breached, you could sue. There's a lot at stake here, right? If the mortgage company, you know, if the Rolls-Royce company just didn't deliver the car, took your 100,000 sterling pounds and didn't deliver the car, can't you sue? And you would, right? You can find an attorney to represent you, and you get damages and all of that. It's worth your time. So should this be ruled out? Well, to be, you know, the argument against contract enforcement here is a little bit weaker. There is value in contract enforcement, but I'm willing to stretch it. I'm saying that while it does provide some kind of security, if you have the other things working really well, you might not need it even there. And so I'm willing to explore, although I'm not on solid ground here, to explore extending this to the full possible scope. Every consumer contract other than insurance would be subject to this kind of no enforcement bar, no contract enforcement bar, and let other things develop and be refined and exist, and let the increased demand for insurance and assurance bonds and for ratings and all of that being, you know, blossoming, you really won't need it even for the Rolls-Royce or for the mortgage product. Yeah, Patrick.
I see the benefit to the proposals for consumer protection, but I don't see what work the one-way contract is doing. It seems like you're just saying it won't do very much work to have a two-way contract, so it'll just cede that ground completely to the companies and don't invest any energy trying to develop that area of consumer protection. So does the one-way contract actually do any work for the consumer, or is it just representative of you saying, let's not even try to approach that?
Yeah. So the arguments here are more subtle, and you know, you don't need to. You could say two things. So Patrick is basically saying, look, all these things that you talk about, the other protections, can exist even in a two-way contract. And in fact, all my examples come from a regime now that is a two-way contract regime, at least in theory. You know, there are assurances, there are ratings, there's zip cars. All of these things exist without having, you know, moving to a one-way contract. Why do we need a one-way contract regime to get them? And so you're right, we don't. We are getting them anyway. But the argument is both methodological and practical. Methodological is, let's just realize that these things exist, and that what is at stake when we talk about remedies, legal remedies for breach of contract, is is not much. To consumer advocates, I'm saying, you're spending your time arguing and lobbying for more remedies to consumers and more access to court so they can sue and get damages for breach of contract. You're wasting your time. There are all these other things that already exist and are developing and can do more. And in fact, if you really want to help consumers, stop advocating for that thing that is not going to work, even if consumer had the access because it's very hard to get lawyers and to get people to actually sue for these things. And instead think about how to develop better insurance products, better, some basic regulation of ratings so that ratings could solve the problem of fraud in ratings or inaccurate ratings or incompatible ratings, all sorts of things that involve coordination. So it is an argument about shifting our priorities. Instead of putting it to one place, putting it another place, and I'm making the rhetorical move that in order to shift priorities, you have to completely eliminate one thing and focus on the others. You're right to say that it's not necessary. There is one subtle argument where I try to place in the paper where I try to argue that having legal remedies actually slows down the development of other protections in the following way. It's not just that the psychological sense that consumers think that they are legally protected so they don't look at ratings. That's, that can explain maybe, that has some explanatory power, not much. And it's not just the argument that regulators need to shift their focus instead of one thing on another. It's the argument that businesses might be reluctant to offer you alternative protections because of the fear that that would signal to you as a consumer that, oh, their promise is probably not reliable. They're giving you a contract, they're giving you promises, and they're also offering you to buy an assurance. Then you might ask yourself, why should I buy an assurance if you give me a contract promise, right? I can always, is the contract not good enough? So there is this sense, you can think about it in the framework of asymmetric information, consumer trying to figure out the value of the promise. The more alternative assurances the consumer has to purchase, the less valuable the promise, or so would a rational consumer infer, and that could slow down the delivery of other protections. So things like this are at play, but I think you highlight an important important perspective on this project. Marcy?
I have kind of a problem with this idea of consumer product insurance. I would assume that, like our current health insurance, that there would be a sizable segment of the population that couldn't afford it. And I'm wondering what's preventing a company from coming in, offering goods at a slightly lower price, but consistently not living up to their end of the bargain simply because they know that this segment can't either sue them and they can't, collect damages or whatever.
Yeah, I think you're right. I think that, to put it bluntly, we cannot solve the problems of poverty with any of these kind of consumer protections. The fact that some people cannot afford better products and get the short end of the stick in many transactions is a problem, and it is disproportionately a problem for poor consumers. I think that if we want to get real serious about it, we don't have to give these poor consumers remedies for breach. So when they buy a cheap pen, they can get a new pen when it's, or something like this. What we need to think about are true progressive redistributive programs that go through the income tax. If we think about all the redistribution that we do in society, and this is a good approximation, 99% of it is done through the tax system, through fiscal programs. They have nothing to do with law, the kind of law that you study in law school other than tax law. Contracts, remedies, torts, takings in property law, all these things where sometimes people say we have to be a little bit more sensitive to the needs of poor consumers or poor parties and give them a disproportionately more generous treatment accounts for the one remaining percent. So I think that while I'm a true believer in redistribution, and I think that it would be wrong to focus our effort and to divert our attention to these issues when we talk about how to create an efficient security system for people, for consumers. Create it the most efficient way to everybody alike, wealthy, poor, indiscriminately. The poor people cannot use it as much, then subsidize it. Use a tax break to get it. Use it and get the redistributive, progressive results that are consistent with whatever your prescription is, and your ideologies might differ on this, through the tax system, not by using a more fair, more redistributively kind of conscious, but otherwise more clumsy private law scheme. That I don't think is a good way to go about. Yeah, Mike.
So why a one-way contract rather than just no contract? I mean, you know, the answer I sort of anticipate is, well, there's no Expedia.com for, you know, consumers of hotels, but buyers on eBay have ratings. You know, most of us have credit ratings, so, you know, maybe the business can still get that information. So why does the business need the contract when the consumer doesn't?
It's a good, you know, it's the whole, maybe you want to argue that also the other component also is not necessary. I don't think that it would be the same kind of argument, because for one, the business does have a practical way to get remedies from the breaching consumer. They can sue consumers, they can threaten to ruin their credit rating, they can send collection agencies, they sometimes even do it excessively when they don't have a right. But they do have the power to do it, so taking it away from them is taking something substantial that they otherwise use. It's not something redundant, as I said about consumer, the right to sue, which is worthless anyway. For businesses, it's not worthless. I also think that but that's a wholly different topic and has to do with my project on equal access. I think that it's not going to help consumers. I think consumers are better off living in a regime in which they can be chased by the business when the business thinks that they are breaching the contract. The reason is that the business then knows they don't have to charge you for the risk that you won't pay. If you promise to pay, they'll get their money. And so honest consumers that don't intend to cheat anyway will not have to add a premium to fund the business's cost of having to go after the less honest consumer. In other words, to say it maybe simpler, maybe more, I'm not sure it's simpler, but there are different types of consumers. Some are cheaters and some are honest. And the right of the business to go after the cheaters is good for the honest consumers. It avoids a cross-subsidy. And since I think that there's a lot of cheating that consumers do, just as businesses do, but if it's pretty prevalent, it's important that the honest consumers will not have to bear that cost.
Thinking back to the example that you put forward, sort of being the impetus. I mean, part of the problem with our current crisis was, in fact, a crisis of rating agencies, and part of what we've seen is, in fact, the very insurers who are supposed to be insuring a lot of different things are themselves failing. And so, how do you? I mean, you know, you're sort of offloading the risk from one side onto the other, yeah. but we're finding those things are part of our current problem. How do you solve for that?
Good. I don't know. I think I can't solve all the problems, but here I can say, I can dodge it by saying, to the extent that we can fix the problem with insurance, you know, and with ratings. And I think we don't see a total collapse of all insurance and all ratings. We see a problem with, not actually with insurance, but with insurance companies that started doing non-insurance things like credit default swaps, which are not insurance. They have to do with risk, but it's not an insurance product. Or we saw some problems with ratings, but again, not the failure of relative ratings, not realizing that a good business is better than a bad business, but the failure of the total system as a whole. It all gave us a sense that on average we're better off, and it turns out that on average we're worse off. Nevertheless, I'm struggling with this, and I've had meetings with experts on financial products to try to think together how you develop a rating system that goes to consumers. We have ratings of insurance companies and of creditors, but that's done for investors. Sophisticated investors are the readers of these ratings. What about consumers, the borrowers, the holders of, you saw a piece a week ago in the New York Times on prepaid debit cards. You put $100, it turns out you only have 70 there because the fees eat up everything else. And you don't know that. You're surprised. Every time you swipe, $2 are off just for a fee. How do you rate these things? Well, the solution today is disclosures. Give people some forms that they sign, and it tells them all the millions of fees as if they can read it, as if they can aggregate, as if they can compare. There are 20 different fees, and each one is, on each parameter, all cards are different. It's hard to know. What about having just a simple rating that says, for the average consumer, and although people are not average, but for the average consumer, out of $100, this is what they get. They call it the card that will be 95. That's not how much money you have left. And there is a card with 80. There's a card with 70. You just want to know the average amount of money that an average consumer has left on the card every time they put in 100. Just one number, a rating number. You don't need the government to provide it. It's very easy to aggregate this kind of information based on some surveys. And the only thing that the government has to mandate is that when Walmart or any retailer sells these cards, there is a rack at the store where the cards are hanging, plastered to some cardboard and are sold, that there would be the rating. That this has to be provided, the one number. More than one number is too complicated to digest and to compare. But one number, I don't see why that would be, why that would not be a good first cut at protecting the consumers, better than giving them the right to join a class action. It is definitely better than mandated disclosures.
I could foresee an issue because the insurance model under this system has a direct effect on the retailers. The retailers are motivated to make their products better so they don't get blacklisted, but then people who just decide not to buy insurance would benefit from that system because the retailers don't know who's buying the products. They don't know who has insurance and who doesn't. So under this model, you wouldn't actually have to buy insurance. The people who are buying the insurance are doing all the work.
Mm-hmm. That's a great point. I didn't think about that. And that could lead to an unraveling of the insurance market. You say to yourself, why should I buy insurance and pay for it? I'll just buy from a company that I know by reading the policies of the insurance company, which I don't buy, that these are companies that are in the gold list, the best companies that most people are encouraged to buy from because they don't breach. That's all I need to know. But why do these companies, why are they part of the gold list? Because the insurance product exists and they are afraid of insurance companies blacklisting them. So you need people to buy insurance, but they won't. Right? You see, it's a type of a free rider problem. So it's a nice bug that I think you have to think about. I don't, I'm not sure that in the end it'll be fatal for the scheme, but you're absolutely right that the scheme has to be thought out with more care than I currently presented it. Thank you. Maybe that's a good time to stop. So thanks for coming.